May I please, the Lordship?
Yes.
Lordship, I beg to mention hearing item number 13, Lordship.
Yes.
Lordship, I pray that this matter come after 3 weeks, Lordship.
Okay. As per policy of the 3 weeks.
May I please, Your Lordship?
Yes. Yes.
I beg to mention item number 12.
Yes.
My senior is indisposed. Kindly list this matter after 2 weeks.
After?
2 weeks.
As per policy of the 2 weeks.
Obliged.
Please, Your Lordship. Your Lordship, I beg to mention item number 8.
Yes.
Your Lordship, kindly let the matter come up after 3 weeks. I'm here to receive
As
instructions.
per policy of the 3 weeks.
Yes, Your Lordship.
I'm for the petitioner, Your Lordship.
Any objection?
No objection.
Okay. All right.
May I please, Your Lordship, I also beg to mention item number 7. It was supposed to be heard today, but the State Council is not ready. So if it may be fixed on Thursday, that is 4th.
This Thursday.
Yes, Your Lordship.
Okay. As per policy on Thursday.
I pledge.
May I please, Your Lordship. Your Lordship, I beg to mention item number 3 on behalf of my senior, Mr. Gauhati, CGC. Respondent number 5. We are yet to file our affidavit in opposition, so I pray that this matter may be listed after 3 weeks.
As per policy of the 3 weeks. Yes. You have got a petition?
Yes,
Do
yes,
you
Your
have,
Lordship.
do you have any objections?
No objection, Your Lordship.
Okay. I pass the order.
Please, Lordship. Lordship, I beg to mention item number 1.
Yes.
Lordship, I pray that this matter come up after 2 weeks. I've taken the consent of the petitioner.
As per listed after 2 weeks.
Obliged, Your Lordship.
Yes. Am I audible? No.
May I please, Your Lordship? I beg to mention item number 2.
Yes. What is the mention?
Like, after 2 weeks,
As per listed after 2 weeks.
much obliged.
May you please, Your Lordship? Your Lordship, I beg to mention item 12. I have taken the consent of the petitioner. Let the matter be posted after 2 weeks, Your Lordship.
Okay.
Obliged.
For admission, item number 4.
May I please, Your Lordship?
Yes.
Lordship, here the petitioner is approaching this honorable court for invalid pension, Lordship. Now, first, I'd like to state some facts that he was appointed as a constable. And then, after appointment, he was attached to the 10th Commandant, 7 NAB, Padland Twinchang. And then when he was on
Counter
deputy
affidavits have been filed.
Lordship,
Evidence have been filed.
counter has been filed.
Yes.
And then they are also ready to hear the case.
You are ready? You are ready? Okay. Yes.
So, Lordship, the appointment order of the petitioner is at page 14. This is the appointment order. And then for more clarity, Lordship, page 15 is the type copy. So this is the appointment of the petitioner, Lordship. Having been declared medically fit by the RMO 3rd Padland NAB, Shri Mangi Chang, son of such and such, village and such, is appointed as GT Constable with effect from 23/8/83 against the existing vacancy of this unit. He will be entitled to throw such and such salary and other allowances are admissible under the rules from time to time. The appointment is purely temporary and subject to verification of the character and antecedent. So, Lordship, after the appointment was made, he was on the petition, and then while working, unfortunately, his fingers were chopped out. So, thereafter, Lordship, the authority has advised and even discouraged not to continue in service. So accordingly, the petitioner invalid pension was forwarded, Lordship, and thereby, Lordship, the approval and the release order of the petitioner, Your Lordship may kindly turn to page 17, and then the type copy is at page 18. So, Lordship may be allowed to read this one. This is important, Lordship. Subject is release order from service and on invalid retirement. You are hereby informed that your application for leaving service on retirement has been approved by the Director General of Inspector of Police, Nagaland, White Letter Number and such, dated 18/1/91. You are hereby released from the unit with effect from the foreign note of 1/4/91, and following documents information may be submitted to this office for process of your pension case to the head of department. So the first paragraph is it reflects the approval of the Director General of Police, the head of the police department. And then the second paragraph is the release order. So accordingly, Lordship, this approval order and then release order was issued by the Commandant, 3rd Battalion NAV Dunsang, on 28 March 1981. Now, Lordship, what happened, Lordship? After the release and then this release from the service, the petitioner was expecting for the invalid pension, Lordship. But due to non-consideration, Lordship, the petitioner was compelled to make one representation, that is at page 19, Lordship, annexure 4. Page 19, Lordship. Now, Lordship, I'm bringing the facts of the case, Lordship. Subject is grievances of a government servant regarding non-payment of pensionary benefits. So, sir, most humbly and respectfully, I have the honor to state the following few lines for favor of the Procedural and further sympathetic action, please. That, sir, I was serving under establishment of Commandant, 3rd Navy, Battalion Dunsang, in the capacity of Lance Knight. That, sir, I have met with an incident while on duty, and as a result, my 2 fingers were chopped, and then Commandant Shri Zabimulota advised me to get released from service on invalidation pension, as I was assured of pensionary benefits on medical ground. But I was not given any type of pension or monetary benefits, and my pension case was rejected by the PHQ due to the length of my service was only 7 years and 7 months. That was the reason, Lordship. That, sir, I have come to learn that now my pension is ineligible to be paid, and thereafter I requested you, kind authority, to kindly forward my petition to PHQ so that I am met with justice and given pensionary benefits. For which I offer kindness, I shall give him. This is the second request letter met on 16/7/95. Now, left thereafter, Lordship, since there was no response, positive response from the department, the petitioner was again compelled to make a representation, Lordship, duly guided by some friends, Lordship. So that is, since petitioner was is illiterate, Lordship, page 20, this is the representation. So page 20, Lordship, representation in regard to my invalid pension benefit and other service benefits. So this is the last representation made by the petitioner, stating all the grievances before the authority to consider the Lordship invalid pension. But despite of this, Lordship, till now this invalid pension was not granted to the petitioner, and such and a consequence, the petitioner is approaching this honorable court, Lordship. Now, Lordship, the state respondent has already filed a counter. Now, in their counter, Lordship, they have stated that I have been given some amount. Lordship, if Lordship can kindly turn to the counter affidavit in opposition filed by the state respondent, Lordship. They have affidavit in opposition filed by the state respondent, Lordship.
What is the date of representation? At page 19?
16795. Just behind the signature of the applicant. 16795.
16,
16795.
95.
Yes.
And what is the
And then the last representation, Lordship, is 29/4/21. The last 29/4/21.
from where do you get that?
It is written on the left side of the representation, the first, page 20, just a copy. That is page 20, Lordship. So, Lordship, to supplement my facts of the case, Lordship, see, Lordship, the petitioner has obtained all his documents, relevant documents, through filing through RDI. So, in that way, the Lordship, the petitioner has obtained the release order, this and that, Lordship. Now, coming to Lordship, the affidavit in opposition filed by the state respondent. Mostly the paragraph number 8 of the affidavit in opposition, Lordship.
Yes.
I may be allowed to read, Lordship. That with regard to paragraph 6, the deponent begs to state that after the release of the petitioner from service on invalid retirement, he approached the state respondent on several occasions to pursue his pension case. It may be mentioned that the petitioner himself has stated that he approached PHQ sometime back in 1991. During that visit, an accountant of PHQ has informed him that his pension case cannot be considered due to less length of service here. The petitioner also stated that he left all his papers with the accountant at BHQ and went back to Tuinsang. Petitioner also stated that he was given 25,000 at the battalion headquarters office. Later on, it was explained to him as his GPF, General Provident Fund amount, and after a few months later, he was given another amount of 7,000, which was mentioned as his heir. Now they are saying that the petitioner has been given his GPF and some another 7,000. If so, let the record be produced, but here it is only their statement. Now, according to me, according to my petitioner, all those pensioner benefits were not given to him at all. Now, Lordship, here the whole question of law, Lordship, is the length of service. Now, I'll come to that. I'll come to that and then try to convince this honorable court that as per this pension service rule, central service rule, there is no prescription for invalid pension. That I'll bring to you, Lordship. And then this honorable court has passed a similar case where invalid pension was granted despite of the list. In that case, some few months were there to reach 10 years. So in that central pension, there is no prescribed period for invalid pension. This honorable court has directed the respondent to consider for invalid pension. And then second, Lordship, I'll give another 2 citation on the claim of the pension. There is no prescribed date for claiming the pension. Suppose if there may be a restriction. If after a lapse of so many years, if the litigant approached this honorable court on the lapses and delay, if it affects the third party, Lordship, then there may be a restriction. But on the claim of the heirs and claim, there is no restriction. So in that line, I'd like to place some authority, Lordship. But before that, let me place first place before this honorable court one judgment passed by this honorable court. By this order, it will cover the present case, though the facts are different, but there are so many similarities in this in present this case. So I'd like to place one covered case.
Before the judgment, which is the provision for invalid pension?
Lordship, I'll because it is stated in this judgment, I'll indicate the paragraph, Lordship.
No.
So
Let us look at the primary source.
Okay. So that relevancy, Lordship, the paragraph 3 of the covered case, I may be allowed to read. Mr. Limao,
Is there any rules for invalid pension?
Lordship, Central Civil Service Pension Rules, 1972.
Let us look at that.
Rule 34. Rule 34.
Yes.
Rule 34.
Let us read that.
Okay, Lordship. Lordship, though since it has been abstract in this judgment, I may be allowed to read this relevant paragraph.
That was in the context of some different case.
Yes.
Okay.
And then
Bottom line,
that has been reflected, the section Rule
person-
34. Rule 34 has been reflected here, Lordship. That's why because I don't have that.
Why not we look at the rule itself?
Okay, Lordship.
Huh? Somebody has written about the rule in that judgment.
Yeah, Lordship.
We will look at the judgment.
Lordship.
No hurry. But let us look at the primary
Lordship.
source.
Lordship.
Central Civil Services Pension Rules, 1972.
Yes, Lordship. 1972.
Does it apply to you?
Lordship, we are the government of Nagaland is applying that is Central Service Rule.
Hmm? You are Mr.
Your Lordship,
You are Mr.
S. Temjin, Lordship.
S. Temjan.
Lordship.
Does this rule apply to you?
Lordship. It is
us-
governed. The state of Nagaland employee is governed by this central service rule, civil service rule, pension rule,
Even the police force also.
even the police force. Because Lordship, the exact similar case has been disposed of, Lordship. So I'm sorry that I don't have the relevant books. But if your Lordship allowed because it is abstract, Lordship.
Okay.
Mr. Limawang Learned Counsel for the petitioner
Do you
submit
have
the
a copy for the court?
yes, yeah, Lordship. So, Lordship this is a similar case decided by this Honorable Court, Lordship. The paragraph 3, page 3, paragraph 3. This was 2015 order, Lordship, 14/5/2015 order. So, the paragraph 3, Lordship. Mr. Limawabang Learned Counsel for the petition submits that under the Central Service Pension Rules 1972, in short, the Pension Rules 1972, more particularly Rule 34 provides that there is no prescription for length of service, and therefore the respondent cannot import something which is not provided under the Pension Rules 1972. The contention of the state respondent that as per the petition has not completed 10 years of service and therefore he is not entitled to invalid pension benefit is therefore not tenable in law, and therefore a direction be issued to the respondent to forthwith settle the invalid pension in favor of the petitioner. Now coming to Lordship. 4. Learned Counsel of the petitioner has also drawn attention of this court to the case of Lakeswar Das versus Union of India and others, reported in 2014-2 GLD 868, wherein in a similar manner, this court has observed the extent and rule of Rule 38 cannot be controlled by Rule 49 by reading words which are not there in the statute. Now, maybe Lordship, the 6, page 4. Mr. Fosico Leonard, standing counsel for the AG, because pension mostly deal with the approval of the AG. So AG was made as a party in this case. So the observation of the Honorable Court, Lordship, Mr. Fosico Leonard, standing counsel for the AG, Nagali submit that Invalid pension is not based on the qualifying service, but depends on the medical certificate issued by the appropriate medical authority. Now, 8. This court is of the considered opinion that Rule 38 of the Pension Rule 1972 indicates that there is a no prescription with regard to land of service, or that invalid pension shall be admissible only on completion of 10 years of qualifying land of service. In the case in hand, the appropriate authority had constituted a district medical board for examination of the petitioner. Thereafter, district medical board had found the petitioner to be unfit for continuation in service and therefore had issued a medical certificate on 17/7/2007. Considering number 9, considering the submission forwarded by Land Council Advocate that Rule 49 is to be read with Rule 38, this court does not see any logic behind the submission to Land Government Advocate, inasmuch as Rule 49 of the Pension Rule 1972 provides for amount of pension, and the same cannot be applicable insofar as entitled for invalid pension is concerned. Now, the paragraph 10, the relevant portion, maybe, Lordship, the next page, page 5. In that paragraph 10, the last paragraph. As such, the answer deponent humbly submits that pension of a government servant is determined by the Rule 49 of the CCS pension rules, and accordingly, the petitioner is not entitled to any normal pensionary benefit, but is entitled only invalid pension as described under Rule 38 of CCS pension rules. So here the petitioner is asking for invalid pension. And then here also it clearly indicates not for normal other pensionary benefit, but he is entitled, whoever is entitled is for invalid pension. Now, so accordingly, this Honorable Court has disposed by a direction, that is paragraph 12. Accordingly, the respondent are directed to forward the text steps to process the pension papers of the petitioner. Let such step be completed within 1 month from the date of receipt of the certificate copy of this order. Thereafter, the respondent for shall ensure that invalid pension of the petitioner is settled as early as possible, however, not less than 3 months from the date of receipt of pension papers of the petitioner to be placed before the respondent for by the settlement. Now, this is the similar case which has been decided, and then this is the authority given by this Honorable Court. So by this, the present case is also covered in the Lordship. Now, I'd like to place a short, brief citation, authority, Lordship, on the delay of this filing this petition pension. This is, Lordship, SCC 2008, William 8. Like to,
Have you given the list of books?
pardon, please.
Have you given the list of books?
Yes, Lordship, I have.
Yes.
Now, the first is 2008 SCC William 8, 648. Here, the question arises. Now, the head note, Lordship. Here, the question is, the head note of the question is, the respondent was declared invalid from Army service on 13/11/1983. He, however, approached the High Court as late as 1999 for grant of disability pension. His writ petition was allowed by the state single charge, but grant of arrears was restricted to the period of 3 years and 2 months, totaling 38 months prior to filing of writ petition. The division bench, however, allowed the respondent error from 13/11/1983 itself. The question was whether relief could be granted to the respondent from 13/11/1983 itself, despite the fact that there was a considerable delay on his part in the approaching the High Court, allowing the bill the Supreme Court held above. Now, the decision, Lordship, I may be allowed to read only the relevant portion. Paragraph 7, 651. Paragraph 7. To summarize, normally, a belated service-related claim will be rejected on the ground of delay and laches. Where remedy is sought by filing a writ petition or remediation, where remedy is sought by an application to the administrative tribunal. One of the exceptions, this is, Lordship, maybe important, Lordship, one of the exceptions to the said rule is cases relating to a continuing wrong. Where a service-related claim is based on a continuing wrong, relief can be granted even if there is a long delay in seeking remedy, with references to the date on which the continuing wrong commenced. If such continuing wrong creates a continuous source of injury, But there is an exception to the exception. If the grievances is in respect of any order of administrative decision which relate to or affect several other also, and if the reopening of the issue would affect the settled rights of third party, then the claim will not be entertained. For example, if the issue relates to payment of fixation of pay or pension, relief may be granted in spite of delay, as it does not affect the rights of the third party. But if the claim involve issue relating to seniority or promotion affecting others, delay would render the claim stale and doctrine of laches limitation will be applied. Insofar as the constitutional relief of recovery of error for a past period is concerned, the principle relating to recurring successive wrong will apply. As a consequence, the High Court will restrict the constitutional relief relating to error removal to a period of 3 years prior to date of filing of the writ petition. Now, Lordship, as I stated earlier, now the petitioner before this honorable court is not asking for any kind of promotion or this and that affecting the third party, but he's asking his claim, his right for the service rendered by him and then the invalid pension. Now, Lordship.
Are you asking for area?
Lordship, I'll come to that. I'll come to that. One citation, only one citation. I'll come to that because see, in this, it was restricted to some 3 years and 38 months, Lordship. But in some one old case, here they have given some kind of compensation, Lordship. So that I just like to place before this honorable court. Lordship, this is AIR 1997, SC 1997, Lordship. Now, this is also related to the pensioner pension. All this authority deals with the pensioner pension. So, Lordship, the relevant portion, I may be allowed to read paragraph 4 only, Lordship. The amount now paid to the appellant admittedly fell due to him much before his retirement. The same was wrongfully withheld. It was, to say that less, improper on the part of the Union of India to plead the power of limitation against such claims of its employee. When it had default in making the payment promptly, when the same fell due, it is not as if the appellant had woken up after a decade of claim his dues. He had been asking the department to pay him his due both while in service and after separation about also, but to no avail. In this circumstance, it is behoved the Union of India to plead power of limitation against the due of appellant. We need say no more about it because better sense has prevailed and claim of the appellant has now been settled and payment made to him. The appellant who had served the department for almost 40 years before his separation was made to run from pillar to post to get his legitimate dues. It is said commendatory of affairs. He has undoubtedly suffered a load, had the amount which has now been found due to and paid, been paid to him at the appropriate time, at least in 1984, when he retired, the appellant would have been safe from a lot of unnecessary harassment. Besides, he would have earned interest on that amount also. He could have utilized that amount for other purpose. He was denied the same on account of the default of the department. That the appellant in his reply to the statement of account filed by Sri Arya in this court has claimed almost 18 lakhs of rupees from the department, out of which more than 16 lakhs have been claimed towards interest and compensation. Now, after that, the observation of the Honorable Court, paragraph 5, after hearing learned counsel for the parties and discussing the matter with them and with the view to settle the equities and to justice between the parties in the peculiar facts and circumstances of this case, we consider it appropriate to direct the respondent Union of India to pay to an appellant a sum of rupees 2 lakhs towards interest, compensation, litigation expenses, etc. for the amount wrongfully withheld from the appellant for more than 12 years up to that, Lordship. So here, the petitioner approaching this honorable court for asking for invalid pension. Besides, Lordship, whatever the pensioner benefits is entitled, the petitioner is seeking this before this court for all those pensioner benefits, whichever is entitled to him, Lordship. And then the Lordship has admitted on the lapses and the delay of filing the petition, as well as the Land of servants, I have already
This
given.
97 decision is not regarding invalid pension.
Yeah, but this is related to older pension. But the non-payment of the pension, it was not the duty of the applicant, but it is a duty of the department. I mean, government of India or maybe the state respondent. So on the default of the department, state respondent, the petitioner should not be allowed. So into that, the court has observed to pay some compensation, Lordship.
You were also sleeping over the matter.
Lordship, see, I have approached the department as well as on the advice, and then it is the department who is supposed to pursue the better, Lordship, because I have already submitted my application, and accordingly, this invalid pension approval was given to me. So it's just to who is supposed to give me the invalid pension.
Yes, what do you say?
Your Lordship, the petitioner was released from service on 28/1/1991, and he approached this
No,
court.
28 3, not 1.
Twenty-eight 1991, and he approached this court after a lapse of 30 years, Your Lordship. After a lapse of 30 years.
Just a moment. He was released from service with effect from 1/4/91, is not it?
91, Lordship. That is page 17, and then type copy is page 18.
Government advocate, is that correct?
Yes, Your Lordship.
One with effect from 1/4/91, is not it?
Yes, with effect from 18/1/1991.
18/1/1991.
Yes, Your Lordship.
From what is this 18/1/91?
This is the release date of releasing
The
the petitioner from service, Lordship.
18/1.
91, 28 March 1991. Lordship, page 18. Type copy, Lordship.
I'm asking the government.
Oh,
advocate.
Lordship.
You also said 18/1. No, not the 18/1.
This is approval made by the Director General of Police,
Ah,
and then release order is 28 March 91.
release order is 28 March 21.
Yes.
Sorry, 91.
Yes.
With effect from 1/4/91. Is that correct?
Yes, Your Lordship.
Second paragraph.
Second paragraph.
Second paragraph.
Yes. Lordship.
Yes, Your Lordship. So Your Lordship is approaching after a lapse of 30 years.
But you were saying something 18/1, 18/1.
Oh. No, Your Lordship, it's 1/4/91. My mistake, Your Lordship.
Okay.
My mistake.
Yes.
And moreover, Your Lordship, here in the release order, the second paragraph, it clearly states all documents, information may be submitted to this office for process of pension case. But Your Lordship, the petitioner never submitted any of his documents to the concerned office. That is the office of the Commandant, 3rd Battalion, NAP, Tuinsang. He is an employee of the office of the Commandant, 3rd Battalion, NAP, and he did not submit any of his documents to the concerned office. Till date, the office has not received any documents from him to process his pension, Your Lordship.
Where have you stated that?
It's in page 18, the typed copy of the release order in the writ petition.
No. That the petitioner did not submit those documents. Where
In
have
my
you stated?
petition, in the affidavit in opposition, it is mentioned in paragraph 8. Not paragraph 8, paragraph 10. Paragraph 10.
Read paragraph 10.
Paragraph,
is-
that
is-
with, that
huh?
with regard to paragraph 9, the deponent begs to state that the petitioner
It is
should,
11.
yes, page 5, the first page 5.
Is that 10 or 11? I think it is 11. There is some correction.
Yes, Your Lordship, paragraph 11.
Okay, yes.
That with regard to paragraph 9, the deponent begs to state that the petitioner should have perused his case for invalid retirement as approved by the DGP and the IGP of police through proper channel, that is the office of the commandant 3rd NAP Battalion, Twinsang, instead of taking it personally and leaving it at the PHQ, which could have added to the delay and lapses in solving his case. Moreover, it is clearly stated in his release order that the required documents for process of pension papers were to be submitted at the office of the commandant 3rd NAP Battalion, Twinsang. So,
But
Your
you have
Lord-
not said that he did not submit the papers.
Yes, Your Lordship, he did not submit his papers to this office.
Where is that sentence?
Here, Your Lordship, the fourth line, through proper channel, that is the office of the commandant 3rd NAP Twinsang. Instead of taking it personally and leaving it at PHQ, he left his documents at PHQ to an accountant. Instead
That
of,
is also a submission.
yes, Your Lordship. With regard to that, Your Lordship, the petitioner has given his statement.
Where?
Your Lordship, the petitioner has given his statement. This is an additional document before the commandant 3rd NAP, where he states that he left his documents at PHQ. He gave it to the accountant at PHQ, and that he has received his GPF and GPF amounting
What
to.
is this?
Your Lordship, that is the statement given by the petitioner before the commandant 3rd NAP.
Have you annexed it in
No,
your
Your Lordship,
affidavit?
I received this after having filed the affidavit.
Then why should we look into this?
This is
This is regarding what?
Lordship, this statement was made only recently, 23/8/21.
This is regarding that 25,000 and 7,000.
yes, Your Lordship,
which was
regarding the
GPF.
amount that he had received.
This has no relevance.
Okay.
What about the pension?
Yes, Your Lordship. Moreover, Your Lordship, if you come to paragraph 12, page 6 of my affidavit,
Yes.
paragraph 14, page 6 of my affidavit, there also I have stated,
Paragraph 14.
yes, Your Lordship, page 6, there
Yes.
also I have stated in fourth line, the concerned office did not take up his pension case as the petitioner had left his pensions at PHQ, and moreover, the office had received no correspondence in connection to the petitioner's case thereafter.
What kind of justification is this? He had left his pension at PSQ.
Pension papers, Your Lordship, at PHQ to the accountant. He submitted his papers there.
That is good. That is good enough. The PSQ should have received it.
But Your Lordship, it was not correspondent back to the 3rd NAP Battalion.
No, this is not justified. This is not a fair action on the part of the state. If you can show that he did not submit the statement made in the counter affidavit, that the petitioner did not submit the required documents, then we will ask him to submit the documents.
Yes, Your Lordship. Yes.
No, where is that? You have not been able to point out. Paragraph 11, you say,
Then, Your Lordship,
Yeah, she said here.
then, Your Lordship, if I may be given 2 weeks' time to file an additional affidavit stating all these statements.
no, you will not get that much of indulgence.
Lordship, in regard to that,
This is a pension matter.
Lordship, in regard to that, I would like to place before this honorable court page 23 of my
Let her complete.
Lordship.
That's it, Your Lordship. And moreover, with regard to the representation he submitted, the office has no records of the petitioner's application also, Your Lordship. It is only with the office of the...
What about the applicability of civil service pension rules
Yes, Your
to
Lordship.
the battalion? It is applicable.
Yes, Your Lordship. CCS
Okay.
pension rule is applicable.
And invalid pension is under Rule 38.
Yes, Your Lordship.
Correct.
Yes, Your Lordship.
It does not say about any length of
Your Lordship, with regard to length of service,
service.
10 years is the qualifying service years, but no clarity has been given whether this 10 years minimum qualification should be for regular pension or for invalid. It covers all the different types of pensions that
Where-
falls under CCS pension.
Where have you stated in the affidavit?
Your Lordship, that I have not stated in the
Huh?
affidavit. I have not stated that in the affidavit.
You have not stated it. Now, on what basis you are saying that minimum years of 10 years
It is there
is
in the
required?
pension rule, Your
Huh?
Lordship. It is there. It is stated there in the CCS pension rules. Minimum
Let us
contract.
point out that provision. You want the rules? Okay, give it. It is there in the rules.
Yes, Your Lordship. My book can- Your Lordship, if I may be given some time to go and get my book. I've marked
Huh?
it there.
You have a different book or what?
No, but I've marked it in my book. So if I may be given some time to go and get it, or Your Lordship, if this matter can be taken up some other time, it's up to you, Your Lordship.
When?
Then Your Lordship, let this matter come up after the listed matter. In the meantime, I'll go and get my book.
Lordship, as Lordship has rightly pointed out, is a pinching case. And then for that submission, I would like to place my record, Lordship.
Before we started hearing the case, a pointed query was made,
Yes, Your Lordship.
whether you are ready or not.
Your Lordship, I may go and get my book then.
Have you read? Have you gone through this judgment, this order?
No, Your Lordship.
Huh?
No, Your Lordship.
Where is your book?
So, Your Lordship,
Huh?
it's there in my chamber, Your
You
Lordship.
don't have any assistant. You want to rely on which provision? Provision of the pension rules.
Yes, Your Lordship.
The petitioner, who was appointed as GD Constable, Mr. What is the date of appointment of the petitioner? Order. What is the date of the order of the appointment petitioner?
Your Lordship. Uh,
Hmm?
23rd 83, Lordship.
Hmm?
Paragraph 2 of my petition. 230883.
And you should have typed it out.
Lordship, it is Lordship. Type copy is at page 15, Lordship.
It is where I am not finding it.
Lordship, apology, Lordship. There's some clerical, Lordship, but I have indicated in my statement, Lordship, in my petition. Paragraph 2. 230883, Lordship.
Yes, your book has come.
Your Lordship, Rule 49. Rule 49, Clause 2. Clause 2A. If I may be allowed to read.
Two.
2A.
Uh,
In
Yes.
case of government servant retiring in accordance with the provisions of these rules before completing the qualifying service of 10 years. Your Lordship, the qualifying
where are you reading?
Rule 49, Clause 2A.
2A, yes. In addition to pension.
Yes, Your Lordship.
Yes.
This is with regard to pension. In case of government servant retiring in accordance with the provisions of these rules before completing.
I am not finding what you are reading. In my book, 2A reads like this. In addition to pension admissible in accordance with. Is it there?
In case of government servant retiring in accordance with the provisions of these rules before completing qualifying service of 10 years.
No, no.
It's
Rule 2A.
no, not Rule 2A. Rule 49 2A. Rule 49 Clause
Correct.
2A.
Rule 49 2A.
Yes, Your Lordship.
What you are reading?
It in my book it reads like in addition to pension admissible in accordance with sub rule 2 after completion of 80 years of age or above. Huh? You are holding
Sis-
FRSR,
Yes, pension rules, Your Lordship.
pension rules. Just a minute. Which page? I hope we are holding the same book. I am holding Swami's compilation of FR and SR,
Lordship.
incorporated orders received up to May 2018. Is this the one?
Yes, Your Lordship, pension rules. This is Sarkar's.
Page number
In my book, it's page number 139.
139. Yes, yes. Yes. I don't think we are holding the same book. So, is this the one? So, is this the one?
Lordship, my friend is referring to the pension. But if she referred to the invalid pension, because I'm here before this honorable court for invalid pension, Lordship. And then that is indicated in 38.
It is 2, not 2A.
Yes, Your Lordship. In my book, it is 2A.
Yours is 2A.
Yes, Your Lordship.
Then we can't read like this. When you read 2A, I can't read 2. Huh? Anyway, what you are trying to read
The
is not related to invalid pension. Huh?
This is with regard to qualifying years of service to avail
Qualifying years
pension.
of service for what?
To avail
Pension. Pension.
Yes, but pension, under the pension category, there are different pensions. So, Your Lordship, invalid pension will also come here.
Invalid pension will
Yes,
also
Your
come
Lordship.
here.
Family pension, invalid pension, all those pensions, Your Lordship. All these pensions are covered by CCS.
Okay. Yes, read. Read.
In the case of government servant retiring in accordance with the provisions of these rules before completing qualifying service of 10 years, amount of service qualifying shall be calculated at the rate of half month's emoluments for every completed 6 monthly period of qualifying service. This is with regard to calculating the amount. Qualifying service now, Your Lordship, in Rule 2Q, it defines qualifying service. Qualifying service means service rendered while on duty or otherwise, which shall be taken into account for the purpose of pensions and gratuity admissible under these rules. So, Your Lordship, the qualifying years is 10 years, and here petitioner has completed 7.5 years, Your Lordship. Before, even when he sought for RTI, also it was clearly stated.
Did you submit a medical certificate?
Lordship,
Yes.
this, as I stated in my facts, that when I was attached with the commandant has discouraged and sometimes some other friends also tease me to take invalid pension. So only they have taken up, I have individual was released from service with effect from 1/4/91 on invalid pension. But BHQ did not accept his request as the length of his service did not qualify for invalid pension. So it controvert their approval, Lordship. They are giving the approval, whereas they are saying this reason, Lordship. And moreover, Lordship has stated this is a covered case, Lordship. Similar case has been decided by this honorable court. And then another friend, he was reading on the amount of pension, which is not relevant in this case. I'm asking for invalid pension. And then when we go for that invalid pension under Rule 38, it clearly mentioned that there is no provision for length of when it deals with invalid pension, Lordship.
All right. The petitioner was appointed as GD Constable with effect from 23/8/83 by an order of appointment dated 23/8/83 issued by the Commandant 3rd Battalion and NAP Transang, Nagaland, by number so and so at page 15, has filed this writ petition seeking a direction to the respondents to pay the petitioner invalid pension. Para. According to the petitioner, as a result of an accident that the petitioner met while the petitioner was on duty, his two fingers were chopped off, and therefore the Commandant 3rd Battalion NAP Twenson by order dated 28 March 1991. I said Commandant. No? By number so and so at page 18 with the approval of the Directorate General and Inspector General Police Nagaland by number PHQ stroke PEN stroke 1684 stroke 90 dated 18/1/91 released the petitioner from the unit or just rewrite this. According to the petitioner, on an application filed by the petitioner for leaving the service on retirement, the Commandant 3rd Battalion NAP Twenson by letter dated 28 March 1991 by number so and so had informed the petitioner is Magi Chang, okay, had informed the petitioner that his application for leaving the service on retirement has been approved by the Directorate Director General and Inspector General of Police, Nagaland, by letter number PHQ stroke PAN stroke 1684 stroke 90 dated 18/1/91, and accordingly the petitioner has been released from the unit with effect from forenoon of 1/4/1991. Full stop. The petitioner, the petitioner, comma, by the aforesaid letter was also informed that was also informed to the petitioner to submit the particulars and documents mentioned therein for his invalid pension. Full stop. You have submitted these documents.
Lordship, this has been submitted, but the reason he have stated is that I have been not completed 10 years. So on that ground, very ground,
Full stop. The petitioner further states that though the petitioner had submitted the aforesaid documents, the aforesaid particulars and documents sought for by the commandant, third battalion and pension, but since his invalid pension remained unpaid, on the inquiry made, it was informed to him that his invalid pension has not been paid, has not been settled because of non-fulfillment of required 10 years length of service, comma, as the petitioner had only completed 7 years and 7 months in service before he was released from the service. Full stop. Accordingly, the petitioner had submitted 2 representations to the Director General of Police, Nagaland, on 16/7/95 and 29/4/21
Lordship.
for payment of his invalid pension, but the same is yet to be paid to the petitioner. Full stop. The petitioner has also referred to a letter dated 20th April 21, written to one of the relative of the petitioner, namely Sri B. Yamlong Chawa Chang, by the Commandant 3rd NAP Battalion Transfer Nagaland by number so at page 23 to indicate that as per the aforesaid letter, the the petitioner's pension has been denied for non-fulfillment of required length of service by the petitioner. Also. Mr.
Ms. Temjen.
Okay, just a moment. Paragraph respondents 1, 2, and 3 have filed counter affidavit contesting the case, contesting the writ petition. The respondent number 1, 2, and 3 have filed a counter affidavit, wherein in paragraph 11 thereof it has been stated that petitioner should have pursued his case for invalid retirement as approved by the Director General Police and Inspector General of Police through proper channel, I, the Office of the Commandant, 3rd NAP Battalion Transfer, instead of taking it personally and leaving it at the PHQ, which have added to the delay and lapses in solving his case. Full stop. It further states that in the release order of the petitioner, required documents for process of pension papers were to be submitted at the office of the Commander, 3rd NAP Battalion, Transfer. Full stop. Have you stated in the writ petition that you have submitted the required papers to the Commandant? I don't think you have stated. In paragraph 14 thereof, it has been further stated that petitioner should have informed the office of the Commandant, 3rd NAP Battalion Transfer about what happened between him and PSQ way back in 1995, Ulster. The concerned office did not take up his pension case as the petitioner had left his pension at PHQ, and moreover the office had received no correspondence in connection to the petitioner's case thereafter. Ulster. Mr. S. Temjen Lal, counsel for the petitioner, has argued that invalid pension, sorry, has argued that invalid pension is paid under Rule 38 of the Central Civil Services within bracket pension rules 1997.
72.
Sorry, 1972. Close to. Under Rule 38 thereof, there is no prescription of any required length of service for payment of a invalid pension. And accordingly, he contends that the ground on which the respondent authorities have not paid the invalid pension to the petitioner till date for non-fulfillment of the required length of required 10 years required 10 required length of 10 years of service is contrary to the law relating to the invalid pension, and the respondent authorities are liable to be directed in this regard also. In support of his contention, Mr. Temzen has placed a decision of this court dated 14/5/2015, rendered in WPC 228 within bracket K 2014, Siluti Au versus State of Nagaland and others. However, however, the contention made regarding completion of 10 years of qualifying length of service for payment of invalid pension under Rule 38 of the Pension Rules 1972 was nullified, and the respondent authorities were directed to pay the invalid pension, notwithstanding the petitioner therein had not completed the required 10 years length of, no, not required, 10 years service. Full stop. Miss, your good name?
AIME.
A.
IME.
Government advocate. On the other hand, by referring to the Rule 49 of the Pension Rules 1972, has argued that
Your Lordship, if I may, Your Lordship, I'd like to place on record the OM of the government with regard to guidelines for invalid pension in Nagaland.
yes, why have you not said incorporated this notification OM in the counter affidavit?
Your Lordship, while filing the affidavit, I did not receive that OM. It's,
This is of 2015.
yes, Your Lordship.
Wait. So and so. During the course of hearing, Mr. So and so, learned government advocate, has brought to the not brought to the notice of this court. OM, OM,
OM number PAR/INV PEN dash 8/2015, dated Kohima, the 22nd December 2015,
issued by
issued by this Government of Nagaland Personal and Administrative Reform Department Pension Cell. Government of
Order
Nagaland
due-
Personal and Administrative Reforms Department under bracket Pension Cell.
order issued by so and so, whereby it has been prescribed that for a person to entitle for a invalid pension, minimum 10 years minimum 10 years 10 years minimum so minimum 10 years of service is required to be rendered.
Lordship, in regard to this, I would like to submit before this.
Yeah, just some in order to for whether it has been provided for invalid pension, the person is required to serve at least 10 years of service. Also, in view of the above, 2 weeks time is granted to the learned government advocate to bring the aforesaid oil on record.
Lordship, I would like to make a short submission. This, my release order was issued way back in 1991. And then this is 2015. Always the notification or rules, whether it is prospective from the day of the notification. And then this rules, it's deviates from the invalid pension of 38, whether it is permissible, because the service rule, the central service rule is applicable in state of Nagaland, where it has been clearly stated in that 38 invalid pension. Nowhere in that rules it is mentioned about
You may be correct. Let us give her an opportunity to this notification also. She is referring to Rule 49 also.
Lordship.
Let her bring these facts on record,
Lordship.
and then you will have an opportunity to reply, because the decision which you have cited,
Lordship.
2014, it it is also not very clear. Though
That-
there is a line saying that Rule 49 of the pension rules is for the pension, not for the invalid pension.
Lordship.
Okay. We'll decide it after 2 weeks.
Lordship. Lordship.
Let's sit after 2 weeks.
Lordship is a Barnhart.
No, it's not a part. It will come after 2 weeks.
Item number 5 and 6.
So, Miss Government Advocate, don't start the case when you are not ready. We will not look into any papers which are not on record, unless, of course, OM can be looked into, and other, like you had contended also that the documents were not submitted. There was no any such statement. We are taking an argument because perhaps they have also not made any specific averments that the petitioner had submitted those documents to the commandant. There's no statement also in a writ petition.
Lordship, see, at the time of submission, my request was rejected on the ground that I have not completed. So on that very point, all my claim has been turned down. So, Lordship, I go by that approval, Lordship.
On the next date, you produce the record also.
Yes, Your Lordship.
Huh? On the next date fixed,
Lordship.
government advocate shall produce the relevant record as well.
Lordship.
Okay. We'll see what is there on the record.
Lordship. Lordship.
May I please, Your Lordship?
Yes.
Here, the issue in this case is that whether a work charge employee on skills survey, having served for 35 years, Your Lordship, is entitled for pension or not, Your Lordship. So here in this case, the petitioner's husband, Your Lordship, page 13, annexure 1, Your Lordship. The petitioner's late husband, Your Lordship, page 13, annexure 1.
This is item number 5 and 6.
Item number 5, Your Lordship.
You are arguing for disclosure.
Yes, Lordship.
Are you ready?
Lordship.
Okay. We will not look into any papers which are not on record. All right? Yes.
Your Lordship, here,
What is this? Yes.
the petitioner's late husband was appointed as work charge Jugali in Scale B under the establishment of the executive engineer, which was passed and issued by the executive engineer PhD Moguchon Division. Page 13, that is a type copy of the appointment order, Your Lordship.
Item number 5.
Yes, Lordship. Page 12 is the appointment order pattern, Your Lordship. It's not clear, so I've made a type copy, which is annexure. Annexure 1, page 13, type copy.
Petitioner retired as casual.
No, Lordship. Work charge feeder grade 2, Your Lordship.
Work charge.
Work charge feeder grade 2.
WC.
Feeder grade 2 on scale.
Peter.
Yes, Lordship. Grade
By
2.
Peter. By Peter.
Feeder, F-I-T-T-E-R, feeder.
Peter.
Grade 2.
Grade 2.
Yes, Lordship.
Yes.
And then at page 15, Your Lordship, again, he was promoted to work charge feeder grade 2, Your Lordship. That is the photocopy of the service book, Your Lordship.
You retired when?
He was retired on 31/3/2014.
31.
3/2014. My retirement order is at page 18, annexure 4, Your Lordship.
Yes.
May I read, Your Lordship?
Yes.
Office order, page 18, annexure 4. In terms of section 3.1 and section 3.2 of the Nagaland Retirement from Public Employment Second Amendment Act 2009, which comes into effect 31st/10/2009 as per the Department notification such and such dated 7 August 2009, Shiri Ikamliwan Konyak work charge feeder grade 2 is hereby released from service with effect from 31/3/2014 on completion of length of 35 years continuous service, Your Lordship. And then it is to be noted that, Your Lordship, the petitioner was a work charge employee on scale serving under a regular establishment, Your Lordship. And then similar employees who have been appointed under the same establishment, Your Lordship, they have approached this honorable court, they have been given regularization order, Your Lordship. So while waiting for regularization, Your Lordship, the petitioner's late husband died, Your Lordship, on 28/3/2015, Your Lordship. On 28/3/2015, the petitioner's late husband passed away, Your Lordship.
20?
28 March 2015.
2015.
Yes, Lordship.
Okay.
So now the petitioner, who is the wife of the deceased, Your Lordship, submitted a representation to the Chief Engineer PhD, Nakalang Kohima, on 1/9/2021, page 19, Your Lordship.
Yes.
This was the representation.
You are entitled for pension.
Yes, Lordship.
Under which you are WC.
Yes,
Work
Lordship.
charge.
Yes, Lordship.
Regular work charge.
Not regular, Lordship. I was not regularized. I was work charge on scale, Your Lordship.
Work charge on the scale.
Yes, Lordship. And then my service was utilized till 35 years length of service, Your Lordship.
Ah. Yes. Do they deny?
They have not replied anything, Your Lordship.
Ah.
But then, Your Lordship, the other similar statute employees who were appointed under the same establishment with me, Your Lordship, the one who was junior to me, they have all been regularized, Your Lordship. I've annexed in my petition, Your Lordship.
Okay. You have to be regularized first and then pay. Pension.
Yes, Lordship.
You are asking for regularization also.
Yes, just for the payment of pension, Your Lordship.
Okay. Yes.
So for that, Your Lordship, may I take you to page 23 of Annexure 7, Your Lordship.
23.
Yes, Lordship.
Yes.
Where a similar statutory employee approached this honorable court for the same period, Your Lordship. That is by order dated 18/7/2018, Your Lordship. The relevant para is at page 25, Your Lordship.
25.
Yes, Lordship. Whereby the work charge employee on scale, it was directed at page 3, the respondent should regularize the service of the petitioner in order to grant him all pensionary benefits in accordance with law. The entire exercise should be completed within 4 months from the date of receipt of a certified copy of this order, Your Lordship. And then accordingly, in the next year also, Your Lordship, page 26, Your Lordship.
Examine the case.
No, Your Lordship.
And if it is found that the petitioner had been working for 35 continuous, okay,
Yes, Lordship.
35 years.
And there were-
This order has been passed to relying on any OM of this memorandum.
Your Lordship, there is an office memorandum we are enclosed at page 21 annexure 6, Your Lordship. Page 21 annexure 6, issued by the Department of PNER on 22nd September 2004 on the subject policy and scheme for regularization of service of work charge employees, Your Lordship.
Yes.
And it,
Petitioner was initially appointed.
Your Lordship,
Petitioner was initially appointed when?
on 17/3/1979 as work charge Chokali on scale.
Okay, 17,
3/1979.
17. Then retired on 31.
Yes, Lordship, 31/3/2014. So, at page 21, Your Lordship,
At page 21.
yes, that's the office memorandum to which Your Lordship, that's for Your Lordship. This is an office memorandum issued by the PNER on 22nd September 2004, Your Lordship. On the subject, policy and scheme for regularization of service of work charge employees. Roman 1, Your Lordship, on the last second para. Each department having work charge employees should maintain a list of work charge employees in various categories in order of their length of service. Roman 2, regularization of work charge employees will be done against available regular vacancies. And on the next page, Roman 3, 50% of all regular vacancies of similar nature arising in a year will be reserved for regularization of work charge employees, and the remaining 50% will be filled up as per normal rules of recruitment, Your Lordship. So this, as per this office memorandum, Your Lordship, work charge is being given the benefit for regularization as per their available vacancy and also as per the seniority, Your Lordship. But then the petitioner husband, Your Lordship, after the retirement on 31/3/2014, while waiting for regularization, Your Lordship, the petitioner husband passed away on 2015, and then in the year 2021, Your Lordship, similar statuted employees were given regularization, Your Lordship, at page 33 and 34, Your Lordship. Annexure 11 and 12, Your Lordship. Page 34, annexure 12, Your Lordship.
Yes.
This is also similar like me, Your Lordship. Here we are one Sherry East Trauma Cognac work charge feeder grade 2 retired with effect from 31/7/2014, Your Lordship. That is, this particular person was retired. I was retired prior to him, Your Lordship. And then his appointment order is 12/7/1979, Your Lordship. On the last paragraph, Your Lordship. Any pension shall be effective from his date of joining the continuous service as work charge staff, that is with effect from 12/7/1979. But then my appointment was on 17/3/1979, Your Lordship. So if the state respondents are following the seniority list as per the office OM, Your Lordship, my service should have been regularized first, Your Lordship. It was passed on 22nd April 2021, Your Lordship. That's why the petitioner submitted a representation before the authority. It was not considered, Your Lordship. So now the petitioner is before this honorable court, Your Lordship, saying that similar statuted employees have clearly given direction by this honorable court for regularization of their services, and accordingly, as I have shown, Your Lordship, page 34 and 33, Your Lordship, those who have approached this honorable court, their service is being regularized and they are getting pension, Your Lordship.
By which order? They had approached this court.
Yes, Your Lordship. The court order which I have shown earlier, Your Lordship, that is annexure 7, page 23, Your Lordship.
Okay.
I've enclosed two rate petitions order, Your Lordship. Annexure 7, page 23, and then annexure 8, page 26.
H. Young.
H.
Konyak.
Iyong Konyak, Your Lordship.
He was appointed when?
Your Lordship,
He-
this particular person was appointed on 31/7/1979
Where it is mentioned?
in the regularization order, that is page 33, Your Lordship.
No, in this order of this court.
In the order, Your Lordship, it has not been reflected, Your Lordship. But then in the department order, regularization order, which was issued by the department, Your Lordship, Page 33, Annex 11, Your Lordship.
Then, on what basis this regularization of this petitioner was directed by this court?
Your Lordship, for that, may I take you to page 23, Annex 7, Your Lordship? I'll just read the relevant paragraph. That is page 24, para 7, Your Lordship. May I read, Your Lordship, para 7?
Yes.
The division bench of this court, by order dated 6/10/2015, passed in Red Appeal 15 of 2013, had upheld the direction passed in the order dated 8/7/2013 by the learned single judge in WBC 213 of 2012, which is as follows. After hearing the learned counsel for the parties and on perusal of the materials on record, we are unable to accept the contentions advanced by the learned additional advocate general Nagaland. State is a model employer and cannot act like a private employer. Being a model employer, it is bound by the constitutional philosophy as expressed by the apex court in a cadena of judgments, reference to which may not be necessary at this stage. Learned single judge had given due consideration to various aspects of the matter and thereafter had taken the view that after rendering 30 years of uninterrupted service, the state cannot deny pensionary benefits to respondent. It has already held by the apex court that pension is not a bounty but an entitlement of an employee, only the quantum depending on the number of years of service rendered. Thus, we agree with the view taken by the learned single judge. It has also been brought to our notice that the various orders have been passed by the state regularizing the service of similar situated work charge employees, thereby enabling them to draw pension, Your Lordship. So, on the basis of this particular writ petition was disposed of, directing the respondents to consider case of the petitioner's Lordship.
Okay. According to this judgment,
Yes, Lordship.
anybody who has completed 30 years
Yes,
of
Lordship.
service, they will be their services will have to be regularized
Yes, Lordship.
and pay pension, isn't it?
Yes, very much, Your Lordship. And then in my case, my service has been July, still 35 years of service, Your Lordship. And then on the basis of that, I may be allowed to submit a short Supreme Court judgment, Your Lordship. Only a paragraph, Your Lordship.
Yes.
Your Lordship, here it is in the case of the state of Gujarat and others versus Dalsipai Tanchipai Padil, Your Lordship. The relevant part, Your Lordship, may I read?
Yes.
It is unfortunate that the state continued to take the services of the respondent as an ad hoc for 30 years and thereafter now to contend that as the services rendered by the respondent are ad hoc, he is not entitled to pensionary benefit. The state cannot be permitted to take the benefit of its own wrong, to take the services continuously for 30 years and thereafter to contend that an employee who is rendered 30 years continuous service shall not be eligible for pension is nothing but unreasonable. As a welfare state, the state as such ought not to have taken such a stand. In the present case, the High Court is not committed any error in directing the state to pay pensionary benefits to the respondent who is retired after rendering more than 30 years service, Your Lordship. So my only prayer is that, Your Lordship, in the line of the Supreme Court judgment,
This young Konyak was senior to you.
yes, Lordship.
Young Konyak was senior.
Yes,
to
very
you.
much, Your Lordship. It can be made out from the appointment order, Your Lordship. At page 34, Annex 12, Your Lordship. This particular person appointment date was on
He is junior to you.
March, Your Lordship. Page 34, Annex 12, Your Lordship.
Okay. Yes, government.
My blessed Lordship, Lordship, may kindly allowed to read paragraph 4 of my counter affidavit, page 2. That with regard to the amendment made in paragraph 5 of the writ petition, the answering demand responded state that the
Paragraph
office
4. Paragraph 4.
Lordship,
Yes.
the answering demand responded states that the office memorandum no AR3 JN67 of 2001 dated 22/9/2004 is a policy decisions of the state government for regularizations of work charge employees. It is categorically stated in paragraph 4 of the office memorandum. Work charge employees will have the right to be considered first for regularization against 50% of all future vacancy of similar nature in the department for which they possess the requisite qualification.
Such regularizations would be considered on the basis of seniority cum merit. This means that the seniority most work judge employees in the relevant category will be regularized subject to his or her fitness for the vacant post. It is further respectfully submitted that the department is doing the regularizations of work judge employee strictly on the basis of seniority cum merit. In other words, it is stated that the senior most work judge in the relevant category is regularized, keeping in view of the policy framed by the state. It is stated that the husband of the petitioner was at serial number 17 as on February 2014 in seniority list among the fitter 2 category in the department. The petitioner, not being the senior in the category during the time of his retirement, was released from service without regularization.
It is all right.
And
You are referring to 2014 notification.
no,
He is saying that there is judgment of this court saying that whoever has completed 30 years should be regularized and paid pension. What do you say on that?
Lordship, the petitioner husband was released from service on 31 3 2014 and passed away on 28 3 2015. And the petitioner submitted the representations on 1 9 2021 for regularization of her late husband past service. Lordship, it is with a delay of more than 7 years, and the petitioner never submitted his representation during his lifetime. It is currently covered in the Civil Appeal No. 4223 of 2022, the State of Nagaland versus Nishibi Achimbi,
Where it is
Annexure 2, page 9.
of your affidavit?
Yes, Lordship.
Yes. Those judgments are set aside or what?
Lordship,
By the Supreme Court? This was directed, it had been 21 of 19. 21. 21 of 19. Yes. Where it is? Which part?
Lordship, page 13.
Page 13.
Yes.
Yes.
Paragraph 41. It is, Lordship, may kindly not be read to read. It is required to be noted that the deceased employee died in the year 2005 during his lifetime. He never claimed any regularization. That the respondent herein originally petitioner, wife of the deceased employee, claimed the regularizations after a period of 12 years from the date of the deceased employee. At the time of the date of the deceased employee, he was not entitled to regularization, as he was much below in the list of the work judge employee whose service were to be regularized. Under the regularization policy, the service of the work judge employees were required to be regularized as per the seniority and as and when the vacancy arises. The service of the other work judge employee, even who were senior to the deceased employee, were regularized in the year 2009, that is, after the date of the deceased employee. Despite the above, the High Court has directed the state to regularize the service of the deceased employee wanted prior to his death, which otherwise his service were not required to be regularized, as his turn had not come, and he was much below in the seniority list. Here in the Shivi case, Lordship, the petitioner husband was expired while in service, and the Shivi case on two grounds the petitioner was dismissed. Number one, delay of 13 years. The petitioner husband has never approached the respondent during the lifetime.
Yes. Supreme Court decision is against you.
Your Lordship, Supreme Court Nishibi's case, Your Lordship, the particular employee died while in service, Your Lordship.
Ah.
And then the judgment which applies, Your Lordship, it talks about the person who retired from service after serving for more than 30 years, Your Lordship. So this judgment is not applicable, Your Lordship. The Nishibi's case, Your Lordship. This particular employee died while in service, Your Lordship.
Ah.
Whereas the one I've served till 35 years length of service. And then while waiting for regularization, in the year 2015, I died, Your Lordship. And also, the department in their affidavit in opposition, they are saying that they are maintaining a seniority list, Your Lordship. Whereas in the year 2014, Your Lordship, similar seated employees who are much more junior to me, they were regularized in the year 2021, Your Lordship. So while waiting for that, I was not regularized, so I submitted a resignation in that year itself, the day when my juniors were regularized, Your Lordship.
Yes. It appears to be a different case. It appears to be a different case.
Out of record, Lordship. I have nothing to say as far as the case is concerned, but I'm appearing for the AG of Accountant General Office. Lordship, Nishivi case is a case. He was working in service. He was working. He died. So he asked for posthumous regularization.
In that,
It's a case of posthumous regularization. While in service, on government bona fide duty, he died.
who?
The Nishivi. In
No,
Nishivi's.
After he retired, he died.
No, the present case, yes. But I'm talking about the Supreme Court judgment, which the government, yes. The person was in service. He died while in service. The wife filed a petition asking for posthumous regularization. So the single bench has upheld, saying that, yes, he should be regularized. The division bench also upheld. The matter was placed before the apex court, Lordship. The apex court said that there are so many people who are above him, and he did not ask for regulation during his lifetime. So the court direction to give him posthumous regularization is wrong. That's what Nishivi's case says about at the apex court. But the case at hand is a bit different. He has worked for more than 35 years.
And it is covered by a division bench judgment of this court.
Yeah, that is my case, Lordship. The division bench case is my case. It went for appeal. They said appeal before the Chief Justice Court. The appeal was dismissed. So the division bench has said that once a person has served for more than 35 years, he has completed his length of service as per the scheme. And in view of the scheme, he should be regularized. That was the case. The division bench, which my learned friend has relied upon. So this should be the apex court decision, and this is a little bit different. Just to clarification, Lordship.
It is writ appeal 15 of 2013.
Yes. That is apparently my case, Lordship.
It is still the law.
Yes.
Okay.
And in the latest 2022 also, the apex court has upheld that once you have utilized the service and you have sent him on retirement, you cannot let him go empty-handed. That is the law, Lordship. But that is out of the record, Lordship, just for clarification. And as far as my stand is concerned, Lordship, unless the government forward the pension to us, we cannot process.
You are also a party here.
Yes, I'm for the AG, Accountant General, respondent number 9.
9.
Yes.
8 also? No.
8,
Treasury officer.
Lordship?
8 also.
No. One do it.
Treasury is different. I'm for the Accountant General, Lordship.
You are for?
Lordship, I am representing my colleague.
Which respondent?
Lordship, I admit that the petitioner is covered by the 2015 OM. Because 2015 says someone who has worked for 30 years and he wasn't with a skill up, he can be regularized. That is what it says. So admittedly, I admit that. The case of the petitioner.
So he dispose of giving direction. And what is the second case?
Your Lordship, second case, this morning only I filed an additional affidavit, Your Lordship. So if the government, if they want to take time, it may be listed after a day or two, Your Lordship.
Okay. Second case.
Yes, Lordship.
The first one can be disposed of.
Yes, Lordship, if the Honorable Court, Your Lordship. Please.
Had Mr.
Subhamati Walling.
For the petitioner, Miss
Pichalo Kitan.
Government Advocate
Lordship.
for 1 to 8.
Yes, Lordship.
And Mr. M. Mozui for respondent number 9. Petitioner here is a wife
Yes, Lordship. It's the wife of the deceased, Your Lordship.
of the disease. Where is that paper? You have shown me
Your Lordship.
that
Appointment order.
office order. Okay, page 18. Huh?
Appointment order is page 12, Your Lordship.
Page 12.
Type copy is on page 13.
Berkshire Jugali. Huh?
Yes, Lordship. On scale.
What is the name of your husband?
Late Ikam Liwang Konyak, Your Lordship. Your Lordship, my.
At serial number 3.
Yes, Lordship.
Okay. The petitioner, who is the wife of late Ehamli Wang Konyak, who was initially appointed as work charge Jugali in the scale of pay
Yes, Lordship.
by order dated 17th March 1979 in the office, no, in the Department
Executive Engineer, PhD Division, Mokokchong.
of PhD, okay, in the office of the Executive Engineer, PhD, Mokokchung Division, by number MKG stroke PHE stroke E dash 4 stroke 78 dash 19 issued by the Executive Engineer PHED Mokokchung, PHE Division, and retired as work charge Peter grade 2 on 31/3/2014 has filed this writ petition for regularization of the service of the late husband of the petitioner and for payment of pension thereafter. Contending that the late husband of the petitioner had retired from service after after completion of 35 years of continuous service in the scale of pay, and therefore the petitioner is entitled to be paid pension
Yes,
for the
Lord.
services the late husband of the petitioner has rendered to the government. First off. In support of in support of our case, the petitioner has relied on a decision of this court dated 6/10/2015, passed in WA number 15K stroke 2013. Whereby it has been held that after rendering 30 years of uninterrupted service, the state cannot deny pensionary benefits to such an employee. Full stop. Relying on the aforesaid judgment of the division bench, order of the division bench of this court, and its counsel has submitted that several orders have been passed by this court directing the respondent authorities to regularize the services of an employee who had rendered continuous service of 30 years,
Yes, Lord.
30 continuous service of 30 years of uninterrupted service and pay the pension thereafter. Full stop. One such writ petition being WPC number 114K of 2018, annexed with Annex 8 to the writ petition. Full stop. Listed respondents, respondents 1 to 8 have contested the case by filing a counter affidavit, wherein in paragraph 4 thereof it has been stated as under full stop. Uh, as under which has been quoted here in below. Full stop. Four and six. Huh? A perusal of decision of the Honorable Supreme Court in the state of Nagaland, rendered in the state of Nagaland versus Nagaland others versus Nisebi Achumi, civil appeal number 4223 of 2022. It appears that the husband of the petitioner therein had died in harness while working as workshop Jugali. After a period of 12 years from the death of the deceased employee, the widow stroke wife of the deceased employee had filed a writ petition before the writ petition claiming that the services of her late husband ought to have been regularized and therefore she is entitled to the family pension. Postal. It was in the aforesaid actual background of the case that the Honorable Supreme Court had held that the services of the deceased employee was not required to be regularized as his turn had not come and he was much below in the seniority list. Poster. In contrast to the decision of the Honorable Supreme Court rendered in Nisemi Achumi Supra, relied on by the government, relied on by the respondents, it has been categorically held by the division bench of this court in WA 15K stroke 2013 by an order dated 6/10/2015 that the Instead, cannot deny pensionary benefits to an employee who had rendered 30 years of uninterrupted service. Full stop. The law laid down by the Division Bench of this court in WA 13K of 2013 is still the law applicable in the state has not been denied by the London State Council. Full stop. In view of the above, since in the instant writ petition there is no dispute that the late husband of the petitioner, who was appointed as work charge Jugali on a scale of pay on 17/3/1979 and retired as work charge Peter grade 2 on 30 on scale pay on scale of pay on 31/3/2014 and thus have rendered 35 years of service,
Yes, Lordship.
have rendered uninterrupted service of 35 years. The petitioner hearing therefore would be entitled to a pension after the services of her deceased of her late husband is regularized by the state authorities in terms of the order of the division bench dated 6/10/2015 passed in WA 15K 2013. First, in view of the above, this petition is hereby disposed of by directing the respondent authorities to regularize the service of the of late what is his name?
Ikam Liwang,
Ekam Ligam
Konyak.
Konyak as work charge Peter grade 2,
Yes, Lordship.
and thereafter pay the pension to the petitioner as admissible under the rules.
Yes, Lordship. Lordship, a specific time period may be given.
Also, the direction given here in above shall be just the process for regularization of the service of late so and so as work charge Peter grade 2 as well as payment of pension thereafter shall be completed by the respondent authorities as expeditiously as possible.
Lordship, kindly grant 6 months.
And in any case,
Your Lordship, similar statute limits have already regularized in the year 2021. So 3 months, Your Lordship.
and in any case, not later than 4 months, okay,
Lordship.
from the date of receipt of a certified copy of the order.
Obliged, Lordship.
I oblige.
Petition is disposed of in terms of. Then item number 6.
Your Lordship, if Chief Medium may come up on
Lordship, may kindly allow 1 week time to go through the additional affidavit filed by the petitioner. This morning I have received.
Okay. And the prayer of learned counsel for the parties, list it after 2 weeks.
Lordship, I
Obliged, Lordship.
Item 9.
May I please, Your Lordship?
Yes.
Your Lordship, by filing the present writ petition, I'm praying for scale of pay.
Scale of pay.
Yes, Your Lordship. The petitioner, she was appointed as work charge, a skilled labor, Your Lordship, on fixed pay.
Ready. Government is ready. Who is appearing for the government?
Lordship, kindly see my,
No. If you are ready, we'll let the petitioner begin.
yes.
Okay. Yes.
Yes, may I continue, Your Lordship?
Yes.
She was appointed as a work charge skilled labor on fixed pay, Your Lordship. And she has been serving the department for more than 25 years. And on 20th July 2022, she made a representation to the department to grant her scale of pay, Your Lordship. However, it was not considered. And
You were appointed on
5th August 1996, 5/8/1996,
as
work charge skilled labor.
work charge skill labor.
Yes, Your Lord.
Yes.
She has made a representation on 20th July 2022 to grant her scale of pay, Your Lordship.
How you are entitled to a scale of pay?
Your Lordship, as per the RTI information furnished by the department, as many as 706 employees who were appointed on fixed pay, they were granted scale of pay, Your Lordship. And as of now, there is no scheme or policy for regularization, for granting scale of pay to fixed pay employees, Your Lordship. It is the discretion of the department. And as per the RTI information, as many as 706 employees who were appointed on fixed pay were subsequently upgraded to scale of pay, Your Lordship.
They were junior to you.
Your Lordship, in the RTI information, their date of appointment has not been reflected, Your Lordship.
Okay. On what basis you are asking for scale of pay?
Your Lordship, as per the RTI information, this many employees were granted scale of pay, but I have been discriminated, Your Lordship.
Those persons have been made a party? No.
No, Your Lordship, I'm not challenging their appointment, Your Lordship.
Who are they? Let's see.
They are all grade 4 employees, work charge schedule.
Where have you stated? Have you taken their
yes,
names?
yes.
Have you taken their names?
No, Your Lordship.
Then
Your Lordship, what my humble submission is that this many employees were granted scale of pay, but I have been discriminated. That is my
who are
humble
they?
submission.
Who are they?
They are all grade 4 employees appointed by the department, Your Lordship.
Where have you stated?
They are all similarly situated to me, Your Lordship.
You are verbally submitting, orally submitting.
No, I have made a plea in paragraph 6, page number 5.
Paragraph 6, page number 5. Yes. Who are they?
Paragraph 6.
Yes.
That so many other similarly situated employees have already been granted scale of pay. However, the department has been indifferent towards the petitioner's plight, and her case has not
Page
become
number?
page number 5, paragraph 6.
Paragraph, so many. You have not taken the names. Yes.
Your Lordship,
Ah.
paragraph 5 of my writ, state
Affidavit.
counter is very clear. There is no policy decision taken by the state to give scale up pay to the work charge employees. There is no policy decision as such, which is so made by the state. I'm representing all the state departments here. So in absence of any policy, framed by the state. Also, mechanically, see para 5 of my
Affidavit.
state counter affidavit.
See, then in that case, you may have to make them a party. Those who you are saying have been granted scale of pay. Government says that there is no policy of the government to grant
Yes, Your Lordship, but my humble submission is that merely because there is no scheme or policy for granting scale of pay to fix pay employees does not give the license to the department to discriminate between similarly situated employees, Your Lordship. And this is a covered case, Your Lordship. I may be allowed to place a reliance on the decision passed by this Honorable Court, the division bench of this Honorable Court, Your Lordship. Your Lordship, in this case, the learned single judge has given a direction to the state respondents to grant scale of pay to the petitioner. And the state government being aggrieved, Your Lordship, they filed this writ petition, which was dismissed by the this Honorable Court, Your Lordship.
scale of direction by the scale of pay, sorry, to grant scale of pay by this court was based on what principle?
The principle of equal pay for equal work, Your Lordship.
Yes, which paragraph?
Page number 15, paragraph 15.
15. Yes,
May I read it, Your Lordship?
yes.
Furthermore, we are in respectful agreement that there is no quarrel with the law laid down by the Honorable Apex Court that equation of posts and determination of pay scale is the primary function of the executive and not the judiciary, and therefore the court ordinarily will not embark upon the task of job evaluation, which is generally left to the expert bodies. It is, however, well settled that the principle of equal pay for equal work is applied when there is complete and wholesale
He is
identity.
relying on Jagjit Singh.
Yes, Your Lordship.
She
So why
might
don't
be
you do
reading the Jagat Singh, whatever it is. Lordship, unless there is a policy frame.
But Jagjit Singh is the law. Huh?
We don't have any policy, Your Lordship, for granting of the scale of pay to the work church employees. I admit, Your Lordship, very clearly in unequivocal terms that yes, Lord, petitioner is a work church employee. But unless there is a policy decision made by the state, how can we randomly grant scale of pay to everyone? That is my only question.
He says
before
that
Your
you have,
Lordship.
she says that you have granted to many others. Huh?
Yes, Your Lordship. Your Lordship may kindly see the RTI reply, Your Lordship, which I've annexed in my writ petition annexure 4A, page number 14.
Yes.
This is my RTI, Your Lordship, where I have sought the information of those employees who were appointed on fixed pay and subsequently upgraded to scale pay. And the reply to the said RTI was made on 12 July 2022, annexure 4B, page number 15, Your Lordship. And if Your Lordship may kindly come to page number 16.
Your Lordship, I have perused the entirety of the writ petition and I have found, I have examined, perused, considered the entirety of the petition, I have found that. But my only submission as a senior counsel for the state is that how, without any policy decision framed by the state for granting of skill pay, how can anyone should be granted skill of pay? That is my only question. I admit.
Yes, yes. Who have been paid?
Yes, Your Lordship.
Who have been granted a scale of pay?
These employees were granted scale of pay. Your Lordship may kindly turn to page number 16.
Yes.
These are all word chart employees, Your Lordship.
Okay.
The date of appointment has not been reflected, Your Lordship. However, the date of granting of scale of pay was reflected, Your Lordship. So since 2000, this many employees were granted scale of pay, Your Lordship. Altogether, 706 of them.
Page 16.
Lordship, who am I to say? But my only thing is that how can we randomly grant to every worker's employee scale up pay?
According to
That is
her,
all.
you have granted to this person without any policy as contended by you.
Lordship, who am I to confront you? But that is my only condition. Who am I to confront your Lordship? But my only submission is that without the policy, any policy decision of the state, as a senior counsel for the state, I am saying before your Lordship that
But you have done it.
I have read it, your Lordship. It has been granted, your Lordship.
Okay. And in the case of petitioner, you will not grant.
No, I'm saying if your Lordship say that no, ratio has to be maintained, then I have no problem for that.
If you admit to this page 16 person, will direct this petitioner also to be granted a scale of pay.
I admit to that. I admit to that.
Petitioner has been serving since 96.
I admit to that. Plus the recent judgment pronounced by this honorable court also, I admit to that. I know these things, your Lordship. It is up to your Lordship before your Lordship to take a decision on the matter. I'll leave it to the wisdom of your Lordship to pass the appropriate order.
What are you now?
Your Lordship, I beg your pardon.
What? You are working as what now?
Yeah, still work as skilled labor.
Skill, work charge, skill level.
Yes, Your Lordship.
And how much you are getting?
5,250.
5,250 is the scale fixed pay.
Yes, Your Lordship.
And what will be the scale of pay of skill level? WC skill level?
Your Lordship, for that, I believe the state respondents. For that, I believe the state respondents will give a better answer.
You must know what this work charge skill level scale of pay is. Point out one from here. Skill level, work charge skill level. From an Excel 16, your RTI information. I don't find any skill level here. I think work charge employees scale of pay is same. Whether khalasi, carpenter, painter, or should be same, is not it?
We have a policy, your Lordship, for work charge in casual employees. And so far as category has been concerned, it doesn't matter. It
Okay.
doesn't matter.
All right,
It doesn't
all right.
matter. Category of the work has been concerned.
That's what I'm saying.
Only the mode of the appointment.
Aha.
The concern is mode of the appointment. Whether someone is appointed as a work charge, contingency, fixed fee, casual, the mode of the appointment matters, your Lordship. The name of the appointment, mode of the appointment, your Lordship. Not the boss.
May I please, Your Lordship? Your Lordship, I may be allowed to place before Your Lordship the office memorandum. 17 March 2015 with regard to the pay scale of work charge employees, Your Lordship. Your Lordship, I have not annexed the office memorandum in my writ petition, but Your Lordship, that's for your reference, Your Lordship.
Third, Miss
V3.
E. Terry, learned counsel for the petitioner, and Mr.
More ancient, Your Lordship. More ancient.
O. Anjan,
Yes,
learned senior government advocate
Lordship.
for the state.
Representing all the state respondents.
Representing all the respondents. The writ petitioner, who was appointed as work charge skill labor in the fixed pay of rupees 750 per month by order dated in the Department of Public Works, Government of Nagaland, by order dated 5th August 1996, and the memo number KPE/EE/EST-24, issued by the executive in the PWD Kipure Division at page 11. And stating to be still working as WC skill labor and drawing a fixed pay of 5,200 per month now, has filed this writ petition for a direction to the respondent authorities to grant the petitioner a scale of pay of the workers' skill level. Contending that the respondent authorities have by now granted scale of pay to as many as 706 employees who were appointed either on casual, ad hoc, work charge, or contingency basis. The names of the 706 such employees who have been granted scale of pay has been annexed as Annex 4B, which is an information furnished to the petitioner. Chuba Imsen is the petitioner.
Yes, Your Lordship.
Chuba Imsen is the petitioner.
Yes, Your Lordship.
Okay. To the petitioner?
He's one of the council.
No. It can't be petitioner. Chuba Imsen is an advocate.
Yes, Your Lordship. His name is also reflected in the cost list. He's my colleague.
Just. He is an advocate for the petitioner.
Yes, Your Lordship.
Okay.
One of the council.
Okay. Chuba Imsen, an advocate for the petitioner. What did they say? Information furnished. Information furnished under RTI to the to Sri Chuba Imchen, an advocate of the petitioner, by the Deputy Chief Engineer and PIO, Office of the Engineer in Chief, NPWD, Nagaland, by number so and so dated 12 July 22 at page 15. Full stop. In support of his contention, the petitioner has relied on the decision of Honorable Supreme Court in the case of State of Punjab versus Jagjit Singh, 2017, 1 SCC 9148. Judgment in order of the Division Bench of this court, dated 21/2023, passed in WA 25/2022. The respondents 1 to 5, have contested the case by filing a counter affidavit, wherein it has been stated that there is no policy or scheme of the state government to grant minimum scale of pay to work charge employees appointed on fixed pay. And in the absence of any specific scheme, stroke policy adopted by the state government for upgradation of fixed pay to scale of pay to work charge employees, the department is not in a position to consider the case of the petitioner. Though the respondents in the counter affidavit has contended the
Your Lordship, whole of my para 5 of my state counter may be reflected in the order, if at all. Because there is a whole of my contention, Your Lordship.
Okay. Just
Whole of the para 5 of my
okay, then
state counter.
contesting the writ petition, the respondents 1 to 5 have filed their counter affidavit, wherein, in paragraph 5 thereof, it has been stated as under, which has been reproduced here in below. quote unquote, para 5. Para, though the respondents have contended the absence of a policy stock scheme by the state government to grant of minimum scale of pay to work as employed. Yet it has not been denied that the petitioner has been working as work as skilled labor since 5/8/1996 and as many as 706 casual, ad hoc, workers, and contingency employees have been granted scale of pay since the year 2000. First, in the department, huh? In the first one. Since the state respondents have admitted to granting of the scale of pay, granting of scale pay to as many as 706 casual, ad hoc, workers and contingency employees of the department since the year 2000, despite there being any policy stock scheme of the government for grant of scale of pay. I find no reason as to why the petitioner, who is a work charge skill level on a fixed pay since the year 5/8/96, should also not be granted a scale of pay as have been granted to the 706 casual, ad hoc, workers and contingency employees, as mentioned here in the poster. Accordingly, this petition is thereby disposed of by directing the respondent authority to grant the petitioner scale of pay of workers skill level as have been granted to the 706 employees. 706 casual, ad hoc, workers and contingency employees who have been granted scale of pay since the year 2000, as informed to Sri Chuba Imchen, advocate of the petitioner, by the Deputy Chief Engineer and PIO, Office of the Engineer in Chief, NPWD, by number so and so, dated 12 July 2022, page 15.
Your Lordship, a time frame may be given.
Full stop. The direction, full stop. The process for grant of work charge skill level, grant of skill pay of work charge skill level to the petitioner as directed herein above shall be completed as expeditiously as possible, and in any case not later than 3 months from the date of receipt of the certificate copy of the order. A petition is disposed of with the above direction.
Highly obliged, Your Lordship.
Obliged, Your Lordship.
We'll complete. Complete. Yes.
No, please, Your Lordship. For
Yes.
item number 10 and 11, on behalf of my senior, Mr. N. Mozoy, I pray for 3 weeks' time to file our affidavit.
Okay. Government.
Engage counsel, my senior, Mr. N. Mozoy.
N. Mozi.
Lordship.
For which respondent?
2 and 3.
2 and 3. 2 and 3 is a state respondent or a private respondent?
Department of the Principal Secretary of Health and Family Welfare and the Principal Director of Health and Family Welfare.
Okay. We'll grant time.
Yes, Lordship.
Yes.
There is an interim, Lordship, in both
Okay.
item 10 and 11.
In the prayer made on behalf of Mr. N. Mozi. Huh?
Lordship.
Council representing respondents 2 and 3.
Lordship.
2 weeks time is granted for filing of a counter
3 weeks'
affidavit.
time, Lordship.
3 weeks time is granted for filing of a counter affidavit.
Lordship.
Please sit after 3 weeks as prayed for. Interim order passed earlier shall continue till the next date of listing. Yes, 11.
Obliged, Your Lordship.
Okay, say item 10 and 11. Same.
Yes, Lordship.
Okay, same order.
Obliged.